Hello everyone, this is lesson 3.2, but before we proceed, let us first have a quick review of the definition of quasi-judicial power. So quasi-judicial power is the power of administrative authorities to make determinations of facts in the performance of their official duties and to apply the law as they construe it to the facts so found. It partakes the nature of judicial power but is exercised by a person other than a judge. And when we say quasi-judicial power, this is also coupled with administrative due process. So administrative due process refers to the fundamental principle that individuals are entitled to fair treatment and procedural safeguards when they interact with administrative agencies. So this principle ensures that individuals have the opportunity to be heard, present evidence, and challenge decisions that affect their rights or interest in administrative proceedings. Remember that administrative due process is summary in nature. It is also not bound by technical rules of procedure and evidence. Always remember that technical rules of procedure and of evidence prevailing in courts of law and equity are not controlling in administrative proceedings to free administrative boards or agencies from the compulsion of technical rules so that mere admission of matter which would be deemed incompetent in judicial proceedings would not invalidate an administrative order. Again, administrative due process is the opportunity to be heard, which includes the opportunity to explain one side or the opportunity to seek reconsideration of an adverse decision. Remember also, class, that the law prohibits absolute absence of previous notice and the lack of opportunity to be heard. So when we say procedural due process in administrative proceedings, this refers to the fair treatment and procedural safeguards that individuals are entitled to in legal or administrative proceedings. So in administrative proceedings, class, such as hearings before government agencies or regulatory bodies, procedural due process ensures that individuals have a chance to present their side of the story and defend their rights. And when we say opportunity to be heard, this is always present in procedural due process. This means that individuals involved in administrative proceedings have the right to explain their position, provide evidence, and respond to any allegations made against them. And whenever there is already a decision, the individual may also seek reconsideration. Meaning, procedural due process includes the opportunity to seek reconsideration of an adverse decision. So if an individual class receives an unfavorable decision from an administrative body, meron po silang right to request that the decision be reviewed or reconsidered. Balik po tayo sa notice and opportunity to be heard. What then is the absence, class, of previous notice? So this refers to the situation kung saan ang individual po na involved in illegal proceedings do not receive prior notification or warning about the proceedings or the action that may affect their rights or interests. So previous notice typically includes informing individuals about the time, place, and nature of the proceedings as well as the specific issues or allegations that they need to address. So what is absolute absence thereof? This emphasizes, class, that it's not just the absence of notice itself that is prohibited, but the complete absence of any form of notice whatsoever. In other words, it's not merely about failing to provide proper notice, but about entirely neglecting to inform the individuals na kasangkot doon sa kaso about the legal proceedings or actions that may affect them. So in essence, the statement suggests that what the law prohibits is not just the absence of prior notice alone, but rather the complete absence of notice and the opportunity to be heard. Partner po sila. Both notice and opportunity to be heard are fundamental components of procedural due process to ensure fairness, transparency, and the protection of individual rights in an administrative proceeding. Sige daw, discuss natin itong Garcia versus Molina case. GR number 157383, August 10, 2010. So respondents Molina and Velasco, class, both held the position of Attorney 5 in GSIS. So nakareceive po sila ng two separate memoranda from Garcia, who is the GSIS president. So ano po ba ang nangyari? President Garcia charged Molina and Velasco with grave misconduct particularly connected with their acts in leading concerted protest activities and or assemblies of GSIS employees against the GSIS president. Si Court of Appeals nullified the formal charges against the respondents kasi po ang sabi ni CA, wala daw po kasing preliminary investigation. This is actually an administrative case. So yung final po ng president against the respondent, is it null and void? Ano ang sabi ng court? Opo, null and void po siya. Bakit? Even though si president po ng GSIS is vested authority and responsibility to remove, suspend, or otherwise discipline GSIS personnel for a cause, yung authority po na ito, even if it is confirmed on him by law, meron po itong limitations. And according po sa Civil Service Rules or the Uniform Rules on Administrative Cases in Civil Service, meron po tayong dapat i-follow na procedure in issuing formal charge against an erring employee. Si CSC po, actually, hindi naman po siya nagre-require na there should be a preliminary investigation, and without it, ang kaso mo ay automatically null and void. Hindi po sinabi ni Civil Service yun. However, it must be noted that upon receipt of a complaint which is sufficient in form and substance, the disciplining authority, yung president po, shall require the person complained of to submit a counter affidavit or comment under oath within 3 days from receipt. Bakit po? Because we must all remember that it is not just the absence of notice itself that is prohibited, but the complete absence of any form of notice whatsoever. Ano nga yung sabi ko kanina? In other words, it is not merely about failing to provide proper notice, but about entirely neglecting to inform individuals about the legal proceedings or actions that may affect them. Ang Civil Service Rule po, gumamit po siya ng shall. The disciplining authority shall require the person complained of to submit a counter affidavit. Ang pag-submit po ng counter affidavit is done prior to the issuance of the formal charge, and the comment required therein is different from the answer that may later be filed by the respondent. And wala po itong exemption. Klaro po ang Civil Service Rules. Lahat ng ipafile mo na kaso, administrative proceedings, you need to inform the respondent. Ang sabi ng court, kailangan si Garcia naman could have issued a memorandum requiring respondents to explain why no disciplinary action should be taken against them instead of immediately issuing formal charges against the respondents. So according to the Garcia versus Molina case, ano ang sabi dito? Although administrative procedural rules are less stringent and often applied more liberally, administrative proceedings are not exempt from basic and fundamental procedural principles, such as the right to due process in investigations and hearings. So in particular class, due process in administrative proceedings has been recognized to include the following. Ano-ano po ito? Number 1, the right to actual or constructive notice to the institution of proceedings which may affect a respondent's legal rights. Another thing is that a real opportunity to be heard personally or with assistance of counsel, and to present witnesses and evidence in one's favor and to defend one's right. Third, a tribunal vested with competent jurisdiction and so constituted as to afford a person charged administratively a reasonable guarantee of honesty as well as impartiality, and a finding by said tribunal which is supported by substantial evidence submitted for consideration during the hearing or contained in the records or made known to the parties affected. Okay, always remember that. Couple po ang prior notice and the opportunity to be heard. Hindi po pwedeng isa lang. Ito din po ang sabi ng Samalio versus Court of Appeals. It is well settled that in administrative cases, the requirement of notice and hearing does not connote full adversarial proceedings. The standard of due process that must be met in administrative tribunals allow a certain degree of latitude as long as fairness is not ignored. So petitioner's assertion in this case that there was no hearing, that he was deprived of the opportunity to be heard, is likewise without merit. Bakit po? Apparently, petitioner's concept of the opportunity to be heard is the opportunity to ventilate one's side in a formal hearing where he can have a face-to-face confrontation with the complainant. Again, sa administrative proceedings po, hindi po kailangan na face-to-face ang inyong trial. Ano bang inire-require ng administrative proceedings? Prior notice po at opportunity to be heard. Kasi pwede namang ma-hear ang side mo through your counter affidavit. However, it is well settled that in administrative cases, the requirements of notice and hearing does not connote full adversarial proceeding. Hindi po ibig sabihin na kailangang magkaharap kayo ng inyong kalaban. Due process in administrative context does not require trial-type proceedings similar to those in courts of justice. Where opportunity to be heard either through oral arguments or through pleadings is accorded, there is no denial of procedural due process. Basta na-inform po kayo at nakapag-submit po kayo ng inyong position paper. A formal or trial-type hearing is not at all times and in all instances essential. Kung pwede naman po palang walang face-to-face, okay lang po yun sa administrative proceedings. The requirements are satisfied where the parties are afforded fair and reasonable opportunity to explain their side of controversy at hand. The standard of due process that must be met in administrative tribunals allow a certain degree of latitude as long as fairness is not ignored. In other words, it is not legally objectionable for being violative of due process for an administrative agency to resolve a case based solely on their position papers, affidavits, or documentary evidence submitted by the parties, as affidavits of witnesses may take place of their direct testimony. Okay? Pakatandaan. Ano yung question dito? Does due process clause encompass the right to be assisted by counsel during an administrative inquiry? Or kailangan mo bang face-to-face? Hindi po kailangan. Ang mahalaga po ay you were properly informed that there is a charge against you and you were given the chance to defend yourself. Again, does the due process clause encompass the right to be assisted by counsel during an administrative inquiry? Hindi rin po kailangan na may abogado. The right to counsel, which may not be waived unless in writing and in the presence of counsel as recognized by the Constitution, is a right of a suspect in a custodial investigation po. Required ang lawyer in a custodial investigation. It is not an absolute right and may thus be invoked or rejected in criminal proceeding and with more reason in an administrative inquiry. This statement class clarifies that the right to counsel as recognized by the Constitution specifically pertains to suspect in custodial investigation. However, this statement asserts that this right is not absolute and may be invoked or waived by individual, particularly in criminal proceedings. Ganyan po kadistinct ang ating administrative law because the right to counsel is not automatically extended to administrative inquiries. And like in criminal proceedings where the presence of a counsel is crucial, administrative inquiries have different objectives and may not always require legal representation. Let us take a look at the case of Lumikid versus Exivea. Anong nangyari dito? Arsenio P. Lumikid class was the regional director of the Department of Agrarian Reform in Cordillera. He was dismissed by President Fidel V. Ramos, which was an aftermath nung meron na pong 3 complaint sa kanya na i-file ng DAR Car Regional Cashier. So dahil may complaint sa kanya, Lumikid submitted his affidavit alleging that the reason the cases were filed against him was to extort money from him. Peperahan lang daw siya. He also admitted that his average daily consumption was 108.45 liters, which is an aggregate consumption of the 5 service vehicle issued to him, and that the receipts were turned over to him by drivers for reimbursement. Nagkandak po ng hearings on the complaints, and Lumikid during those hearings was not assisted by a counsel since he was confident that he can defend himself. So ngayon naman po, the first trial was on July 3 and 10. Noong July 17 po, he was unable to attend the third hearing because nagka-stroke po siya. Now on July 31, ang investigating committee po issued a report finding Lumikid liable for all charges against him. Noong December 17, nag-file po si Lumikid ng motion for reconsideration. But on May 12, President Ramos issued AO number 52 finding Lumikid administratively liable for dishonesty in the alteration of 15 gas receipts, and he was dismissed from service. Noong August 31, 1993, Lumikid filed a petition for appeal but it was denied. He then filed a second motion for reconsideration alleging, ang sinasabi niya po is that he was denied of constitutional right to counsel during the hearing. On September 28, the second motion was denied. Remember, nung sabi niya wala akong abogado. But on May 19, 1994, Lumikid passed away. Ano ba ang sinasabi ni Lumikid? That the investigating committee deprived him of his right to counsel during the hearing. Ano po ang sabi niya? His right to counsel could not be waived unless the waiver was in writing and in the presence of a counsel. So anong issue? Whether or not the due process clause encompassed the right to be assisted by a counsel during an administrative hearing? Hindi po kailangan ng abogado during the administrative hearing. The right to counsel is a right afforded a suspect in an accused during custodial investigation. It is not an absolute right and may thus be invoked or rejected in a criminal proceeding and in an administrative inquiry. Lumikid was not accused of any crime in the proceedings. The investigation that was conducted was for the purpose of determining if he could be held administratively liable under the law for the complaints filed against him. So remember, class, that a party in an administrative inquiry may or may not be assisted by counsel irrespective of the nature of charges and the respondent's capacity to represent himself, and no duty rests on such a body to furnish the person being investigated with a counsel. Hindi po yan duty ng administrative agency. A respondent has the option of engaging the services of the counsel or not. Always remember that. When is the requirement of notice and hearing not necessary? Di ba sabi kanina dapat there should be no absolute absence of notice and hearing? Pero meron palang instances na hindi na kailangan ng notice and hearing in administrative cases. Kailan po yun? The urgency of immediate action, tentativeness of administrative action, grant or revocation of licenses or permits to operate certain businesses affecting public order or morals, summary abatement of nuisance per se which affects safety of the persons or property, preventive suspension of public officer or employee facing administrative charges, cancellation of a passport of a person sought for criminal prosecution, summary proceedings of distraint and levy upon property of a delinquent taxpayer, replacement of a temporary or acting appointee, and the right was previously offered but not claimed. So, what is the quantum of proof required in administrative proceedings? Diba may leveling tayo? Since you are now in second year, I hope that you already know kung ano po ang required na quantum of proof in administrative proceedings. Ano po ba? Only substantial evidence. That amount of relevant evidence that a reasonable mind might accept as adequate to support a conclusion. So ano po bang quantum of proof? This refers to the amount or degree of evidence needed to establish a fact or support a conclusion. So in administrative proceedings, nagre-require lang po siya ng substantial evidence to support the conclusion. So substantial evidence is defined as the amount of relevant evidence that a reasonable mind might accept as adequate to support a conclusion. This standard falls between the higher standard of beyond reasonable doubt used in criminal trials and the lower standard of preponderance of evidence used in civil cases. So ano bang ibig sabihin ng reasonable mind might accept? Ito po must be of such quantity and quality that a reasonable person acting impartially and objectively would find it sufficient to support the conclusion being drawn. Pakaalalahanan po natin that administrative agencies or tribunals are generally tasked with making decisions based on evidence presented to them. So they are required to evaluate the evidence and reach conclusions that are supported by substantial evidence. However, always remember that if a party disagrees with an administrative decision, pwede naman po silang mag-seek ng judicial review. Then, i-assess po yan ng court whether the administrative agency's decision was supported by substantial evidence. This ends our lesson for batch number 3, and I will give you a quiz. I will post your quiz anytime this week. Bye guys, and have a great week ahead.